So, could Lucy Connolly actually sue? Well, obviously anybody can sue anybody for anything, so the better question is, could she sue successfully? And to cut to the chase and avoid all the clickbait, the answers are no, no and possibly. But let me explain. First of all, what am I talking about there? Well, there are several targets and causes of action, so this just gives me an opportunity to talk about them generally. But essentially, the things I've seen people talking about online are suing the police, so that would be malicious prosecution. Suing the Prime Minister, that's a tricky one. I suppose that would have to be some sort of malfeasance or misfeasance in office. But then there's also some potential defamation claims because of what people have been saying about her online. So I'll take those in stages. I mean, the obvious one is malicious prosecution. As the name suggests, malicious prosecution is where you sue somebody for prosecuting you maliciously. And in this, because I've always said before that the word malice in law has numerous meanings that don't really comport necessarily with how we use it colloquially, because of how, the common law's been going so long that words get frozen in time. So when we talk about malice in defamation, we mean, not knowing it's not true or not, checking whether it's true. If we talk about malice in, say, offences against the persons, GBH, malicious wounding, that sounds really bad, but that's actually the lesser offence of wounding with intent. That's a lot less serious, because in that sense it just means sort of recklessly. But malicious prosecution is where you bring a prosecution effectively in bad faith. But what are the elements you need to prove? Well, first of all, the claimant must have been prosecuted by the defendant. So you have to identify who is the correct defendant. And generally, malicious prosecution claims are brought against, quotes, the prosecutor. But who is the prosecutor? Well, it can actually be a police officer, an individual police officer. And a police officer will be considered a prosecutor if they alone know the facts of the alleged offence, they deliberately misstated the facts to the person making the decision to lay the charge, they intend that there should be a prosecution, and that the person who lays the charge could not have formed an independent judgment as to whether a charge should be laid. Because laying, well, we say laying the charge. Actually, I'm old school. I still call it laying an information. Not to be confused with laying a complaint in the magistrates' court. They're slightly different things, and I'll do another video on that, and especially about the cost consequences. And the reason I can talk about that with some authority is I nearly got caught out very badly with that one. But you lay an information, and that's the procedure that kicks everything off. That's the thing that gets people in front of the magistrates, and then, if necessary, all the way to the Crown Court. But you'll see there that if the person who actually lays the information is in a position to make their own decision as to whether to prosecute, then that you go after that person. And in this particular case, it would be the CPS, the Crown Prosecution Service, because for cases like this, they will have reviewed the file, and especially as this, the offence she was actually convicted of, requires the consent of the Attorney General. So, I mean, they don't make the decision themselves usually, they are allowed to delegate it. But in this particular case, the correct defendant would probably be the CPS, because they're the ones who made the decision. I mean, I want to keep this relatively short, because it's a very complex subject, because people might be saying, well, what about the post office people? Well, in that particular case, it's like, well, the prosecutor relying on duff information. So in that particular case, they're looking at, issues of perhaps perverting the course of justice for laying information that was false. But you'd have to show that the prosecutor knew the information was false. And it's a really low threshold. They are allowed to say, well, this is what somebody's alleging, and it's all going to turn on, credibility and witness evidence at court, because the only test they have to do is realistic prospect of conviction and in the public interest to prosecute. So in this particular case, realistic prospect of conviction. Well, yes. I mean, there's no dispute the tweet was sent. There might have been arguments as to intent and things like that, but that's all matters for a jury. When you do that test, you do anticipate. It's not like, is there a prima facie case? It's a slightly higher threshold. It's, well, taking into account everything the defence might say, is there a realistic prospect of conviction? But in a particular case like this, it's unless and until there's a defence case statement where the defence comes in and says, this is what our defence is, well, you don't necessarily know what the defence is going to say. And and while it should be, consider the obvious things. So if it's a punch up outside a kebab shop, will they be able to, could they realistically raise self-defence? You don't have to necessarily wait for them to raise it. You can anticipate that. But in a case like this, it's very difficult to see, what they could have anticipated. Second limb, the case must have been resolved in the claimant's favour. Well, that's going to be a big hurdle because it obviously hasn't. She pleaded guilty, and therefore that counts as a conviction. There was an attempt at an appeal, but that was knocked back. But generally speaking, well, not even generally speaking, you can only actually bring a claim for malicious prosecution if you've been acquitted or the conviction has been overturned on appeal. And neither of those apply here. So in the absence of a further successful appeal, then it just fails at that hurdle because, that is the thing, it's not been resolved in her favour. The third limb, the proceedings must have been brought against the claimant without reasonable grounds or probable cause. Well, like I say, it's, they will have applied that test. And whatever people may think about this case, where there is a tweet like that arguably could be considered to sort of be in breach of the section. And I've done my other video on what I thought about that. I mean, like I say, I do think she might have had a punt had she gone for a jury trial on the first limb. That's the I intended to stir up racial hatred, as opposed to maybe being convicted on the second limb, which is, I didn't intend that, but my voluntary actions could have foreseeably resulted in that. I mean, it's really strange that she didn't ask her lawyer to offer a basis of plea, even though everything had been explained to her, because I think it would have been worth at least floating that basis of plea with the CPS. And even if they rejected it, as they probably would have done, and it went to trial, let's say she was acquitted on the intentional offence, but convicted on the sort of non-intentional version, then they could have said, well, look, she was willing to plead to this, so she should get full credit. But, it was up to her. So that's the thing with punters. We can only advise punters, but we never actually tell them what to do. We very rarely sort of even hint what they should do. We just say, here are the various scenarios, here are the outcomes, and here what we think are the probabilities of success or otherwise, but ultimately it's your decision. The officer or officer's actions, and again this could be the CPS, an intent must have been malicious. And it says, this is a high hurdle and the most difficult part of proving malicious prosecution, as the claimant must establish that the prosecution was malicious and an intentional misuse of the court process, rather than merely a mistaken accusation or conducted negligently. So like I say, it has to be done deliberately. So I think she'd also, even if there was a successful appeal in the future, and it's difficult to see on what grounds that could arise, well, I think it should fail on that hurdle. And the fifth limb is the claimant must have suffered some damage. That would be an easy thing to prove because, you went to prison. So that'd be a relatively simple one. But yeah, I mean, she's fairly stuffed. I mean, she's got no chance whatsoever on malicious prosecution because, first of all, there's the proving malice, but more importantly, it's a slam dunk hurdle that proceedings have not been resolved in her favour. Malicious prosecution is an interesting one because you can bring the claim against a malicious prosecutor. So like I say, that could be the police, the CPS, but it can be against private prosecutors, whether that's a sort of an organisational one, like, the RSPCA do a lot of prosecutions, as does HMRC, and various other bodies, but also private individuals and private companies can bring private prosecutions. You can also bring them not just in relation to criminal cases now, you can bring them in relation to civil proceedings that have a sort of an effect equivalent to a prosecution. So there is a tort, for instance, of bringing a malicious winding up petition. If you bring a winding up petition against a company with just bad faith and not on good grounds, because the consequences are their bank accounts will be frozen, all the reputational harm, then you can actually, you can bring it then. You can also bring them against regulators. There have been cases where people have been sort of disciplined by their regulatory body. And in those cases, they've said that you can actually bring malicious prosecution cases. What about the, can she sue the Prime Minister? Well, no, effectively. First of all, on what? Now, there's like misfeasance and malfeasance in public office. Misfeasance is effectively where you do your job badly. Malfeasance is where you deliberately do your job badly. You see what I mean? One sort of negligent and the other one is intentional. See, we keep coming back to this, don't we? But what could you pin it on? Now, I do think that it was very inappropriate of the Prime Minister to sort of do his little speech about everybody will be dealt with harshly. They are criminals and they will be, remanded in custody. And people say, oh, well, that just put pressure on the judiciary. I think people saying that have a rather optimistic view as to how much, as to what the judiciary actually think of politicians. But like I say, I would like to see the, what happened at the bail hearing, because I think she probably was entitled to bail, or you could certainly have made the argument. But we never actually got that stage. She was remanded in custody. Another little, just being pedantic thing. We talk about on remand and remand. We tend to use remanded synonymously with being held in prison, but technically speaking, a remand is just a type of adjournment. All remands are adjournments, but not all adjournments are remands. And I still don't know to this day, and I was called in 1997 and I've still got no idea what the difference is. But you can actually be remanded on bail. So it's just a colloquial use. You say, he's on remand, if you're Norman Stanley Fletcher or somebody like that. Having said that, I've actually seen official government things actually using on remand as synonymous with being in prison. But what's he done? You can say, well, he's interfering with the independence of the judiciary, but that'd be very hard to prove unless you could sort of find an email or a letter saying, dear judiciary, I want you to ignore the provisions of the Bail Act and just remand people in custody regardless. I just don't think there's anything there. And you can look at, because in the post office thing, there's all, like I say, there's all, perverting the course of justice, perjury, all that sort of thing. Well, none of that applies here because there wasn't a trial. Now you could say, well, maybe the evidence, let's have a look at the witness statements, maybe they're lies, but the witness, the evidence was just, here's some stuff that she said in an interview where she accepts she did the tweet. Nobody tried to exclude the interview because you can apply under section 76 of PACE 1984 and say this interview was somehow unreliable because it came about as either a result of either a threat or an inducement, but there's nothing to suggest that's ever been sort of raised or any suggestion there. So again, it would just be really, really difficult. So I just think, like, in terms of suing the police, the CPS, the Prime Minister, Uncle Tom Cobley, not a chance. However, what about some of the defamation cases? Because, for instance, there's one where somebody said she is a terrorist. Now, obviously, that's a very serious accusation. And, arguably it's defamatory at law. But first of all, is it a statement of fact or is it an opinion? Then there's the defence of, well, even if it is a statement of fact, I've got public interest defence. It's in the public interest to have actually raised this issue and comment on it. So accusing somebody of being a terrorist, what would you actually have to show at court? Well, we'd have the meaning hearing. So they say, what would your average, hypothetical, reasonable reader or viewer, not too sceptical and naive, but not too prone to scandal and gossip, what would they actually think? And in this particular case, I mean, it's just like, well, yeah, it's an accusation of terrorism. So, that's a fairly straightforward thing. So could she get away with opinion? Well, yeah, because if she's related to, gone back to the facts, it's like, well, I think this amounts to terrorism. And there's this idea of what we call stochastic terrorism, where you don't actually say, go out there and do something. You don't incite people, but you just talk about things neutrally or seemingly neutrally in a way that sort of riles people up. So it is very related to the idea of, inciting hatred and things like that, even though you don't explicitly do a call to arms. I mean, we've had a lot, quite a few international criminal court prosecutions based on that. I mean, some of the Rwanda stuff was like that, where they prosecuted people doing the radio stations, and similar in the Balkans, although they just bombed the radio station. But they said the reporting was so biased against a particular group, it was bound to inspire people effectively to take up arms. So there you go. I mean, like I say, I think the defamation claims have a bit of a pump, but of course then she'd have to show, like, serious harm as well. And bearing in mind what her reputation is at the moment, how could she show that? I suppose if you could say, as a result of that being said, I'm now receiving threats online or harassment more than I was before, then arguably, but I just can't see it. So there you go. Just a little summary there. Be very interested in your comments on this one. And as always, hope you found that vaguely interesting, vaguely informative, and vaguely accurate.